All right, Chair, we are live.
Thank you, Hunter. Good morning, everyone, and welcome to the first Misdemeanor Subcommittee meeting of the Nevada Sentencing Commission. I'm going to ask now for NDSP to call roll.
Thank you, Chair. John Ariscata.
Here.
Steve Bishop.
Present.
Christine Jones Brady.
Present.
James Conway. Judge Cynthia Cruz.
Present.
Wes Duncan.
Here.
Jack Esslinger.
Present.
Nick Graham.
This is Zach Young for Nick. He's in a jury trial, so standing in for him part of this morning.
Thank you. Evelyn Grosnick.
Present.
Eve Hannon.
Present.
Judge Kevin Higgins.
Judge Higgins let me know that his calendar got really big this morning and he will be joining late.
Okay. Dr. Lanterman. Christina Mortensen.
Present.
Lisa Mosley Sales. Michael O'Brien.
Present.
John Puro.
Here. Good morning.
Marcy Reba.
Present. Good morning.
Good morning. Elisa Schultz.
Here.
Holly Wellborn. Chair McCormick.
I am here.
Perfect. Chair, we do have a quorum.
Thank you very much, Georgia. All right, so now that we have called the meeting to order and taken roll, it is time for the first period of public comment, which is agenda item number 2. There are 2 periods of public comment, one at the beginning of the meeting and one at the end. Members of the public have 2 options for submitting public comment. First, members of the public may do so in writing by emailing the Department of Sentencing Policy at sentencingpolicy@ndsp.nv.gov. Public comment received in writing will be provided to the subcommittee members and will be included by reference in the meeting minutes. Members of the public who wish to testify may do so by telephone as well. Due to time constraints, public comment will be limited to 2 minutes. Any member of the public that exceeds the 2-minute limit may submit your comments in writing to NDSP. At this time, I will ask the staff, I will ask staff to manage and direct those who will testify by telephone. Ms. Jones?
Thank you, Chair. Members of the public who would like to testify by phone, please press *9 to raise your hand. When it's your turn to speak, please slowly state and spell your first and last name. And it looks like we do not have anyone that wants to participate in public comment.
Thank you, Ms. Jones. Since we have no one to participate in public comment, we will close that agenda item and move on to agenda item 4, which is introduction of the misdemeanor subcommittee members. Now, I think probably a lot of us on this call have run into each other somewhere along the line, but I wanted to give anyone an opportunity to introduce themselves, to make any comment before we get started. So happy to hear that. And we don't have any of that, then I guess we can close agenda item 4 and just power through the agenda to item 5, which is the purpose of the misdemeanor subcommittee. And I'm going to share my screen momentarily here. And good morning. Excuse me. I just wanted to provide a little background on why we're here and what the mission of the Sentencing Commission Subcommittee on Misdemeanors is. This subcommittee was created by Senate Bill 103 of the 2023 session, and specifically in sections 1.3 to 1.7 of that bill. And the bill gives us our charge that we are to study existing laws, policies, and practices related to misdemeanor offenses in this state and other states as necessary, including without limitation sentences imposed for misdemeanors in this state and others, and also to submit a biennial report describing the findings, conclusions, and recommendations of the subcommittee to the Sentencing Commission. The bill had a few requirements for misdemeanor for the membership of the committee, but there's no statutory cap. The statutory requirements are one person who has expertise regarding misdemeanors, administrative assessments, etc., a city attorney, and that's Mr. Duncan, thank you, a criminal defense attorney with misdemeanor experience. We've got Mr. Pirro and Ms. Grosnick on that, and then a justice or municipal court administrator, and we have Mr. Eisinger, I can talk, Jack, Elisa Schultz, Christina Mortensen, and Mr. Conway, and I don't believe he was able to be here today. The important thing here is the mission. Oh, can you see the mission, or am I too dumb to operate this?
I can see it.
Okay, thank you. The mission of the Sentencing Commission Subcommittee on Misdemeanors is to undertake a comprehensive review of misdemeanor offenses in Nevada in order to make data-informed, substantive recommendations to promote justice and fairness across all misdemeanor systems in the state. So with that said, I think, sorry, too lame to operate my computer. Is the purpose, and again, what I would ask for here is if anyone has any sort of specific, and this sort of leads into the next agenda item 6, discussion on areas for study. But my idea here at this first meeting was to have a discussion on what exactly we want to study, what topics we want to look at, as far as the committee, and that will hopefully inform our work. I have a few ideas as to potential areas for study, and I'm going to share that again right now. And those topics, in discussions, Georgia and I, Georgia informed me that she has about an 80-page list of misdemeanor offenses in Nevada. So it's a fairly broad topic that we're going to need to start looking at and developing our ideas on. Again, one of the things we need to look at, in my opinion, and please provide that feedback if necessary, fines and fees. Is our current penalty structure appropriate? Also, should there be a reliance by the state and local courts on administrative assessments, which are added to misdemeanor convictions based upon NRS 176.059 and is based on the amount of fine associated with the offense? Other states have multiple classifications for misdemeanors. Could Nevada benefit from this type of structure? For example, if any of you have ever gotten gas at Quick Stop in Carson City, you'll see that they have a sticker that says it's a Class B misdemeanor to steal gas. We don't actually have that here, but is that something that we as a group think we want to look at, sort of stratifying and classifying misdemeanors and associated penalty structures? Other state, clarification on which misdemeanors are arrestable. This has been a topic, I think, for quite some time. Which are we citing? Which do we arrest for? And is that something that this group thinks we need to consider and make recommendations regarding? Classification of certain offenses. For example, battery constituting domestic violence, driving under the influence are both for the first and second offense currently misdemeanors. Is that a topic that we as a group want to look at? And do we have any feelings about the seriousness of various offenses and their classification? Also, misdemeanor probation status checks and the length of a tail for the length the court can have jurisdiction on misdemeanor defendants. I have anecdotally heard some information that this may be an issue in some jurisdictions, so I think that may be something we also need to look at. Also, currently in the state of Nevada, we have very few jurisdictions comparatively that have departments, misdemeanor probation, departments of alternative sentencing at the local level, and those are all county, city funded. So is that something we want to look at as a group to potentially make recommendations regarding the expansion of that? Also, as most of you know, with passage of AB 116 in 2021, a number of traffic offenses became civil traffic offenses. But however, some remain misdemeanor, and we can provide a list on that if necessary. But there is still confusion, and I think some of our judicial members can speak on this and bleed over between those two and the handling of those cases. So that may be another topic that we as a group want to look at. Also, this kind of goes into data, but what amount of general fund support do counties and cities receive from misdemeanor fines, which is related to this constitutional question? First of all, Article 1, Section 8A of the Nevada Constitution, that's Marcy's law. And then Article 11, Section 3, that is the provision of the Nevada Constitution that requires any fines levied for violations of the crimes of the state to be directed to the state controller for deposit in the permanent school fund. So there's that on the state level versus local charging where it's retained locally. So that may be something we want to look at. Obviously, constitutional amendments may not be our first recommendation, but again, I think it's something important to discuss holistically. Collateral consequences of misdemeanors, driver's license suspensions, professional licensing, firearms. Obviously, when I mentioned firearms, with the Anderson decision from the Nevada Supreme Court regarding battery constituting domestic violence, it requires jury trial now in limited jurisdiction courts because of the collateral consequence and the loss of constitutional right to firearm possession or ownership. And then finally, another topic, and this has always been an interest for me, which maybe says something, but the nexus between offenses, fees, penalties, and the use of those fees. So those are sort of the initial topics I had thought of going into this, but obviously this, I think, is the time for the group to discuss what topics we want to look at, because I think that will help to inform us as we set up our working groups and also discuss what sort of data we need to ask NDSP to collect. And I see that Lisa has her hand up. You're still on mute, Lisa.
I actually did hit the button to try to unmute myself. Good morning, Chair McCormick, Georgia, and to all of the other members. First, let me just say this is very exciting to see this coming to fruition. I wanted to just bring up, we talked all of the data points that you talked about. Also, I think it's very important for us to think about how we're going to collect local municipal data and related to municipal ordinances and county ordinances. One of the things that came up when we were working on this bill was the discrepancies between the state, the county, and municipal misdemeanors. There were different fines, there were different penalties, there were different sentences, and there were some legislators that were concerned. There were some people from the, not public defenders, public defenders also, but also prosecutors. Just everybody had some concern about what the discrepancies were in all of these misdemeanors and these levels. My suggestion is that we take those 80 pages, and it's comprehensive, as I understand. It's all of the misdemeanors at the state level, and use that to guide our working groups and break those up into different categories. They're already categorized for us. The research division did a lot of the work for us. They're already categorized. And as it relates to the traffic ones, they've already gone through and labeled all of those traffic ones that have been decriminalized. So they've done some of that work for us. So that's kind of my suggestion in guiding the working groups. Use that 80 pages of misdemeanors. It is a lot. We've been going through it to guide our working groups, but also think about demographic data also that we should be collecting. All the data points that you said, but also the demographic data. What are the zip codes that we're seeing a lot of these misdemeanors being levied in? What are the most common misdemeanors? Where are they? Who's getting them? Those kinds of things. So those are some of my suggestions and some of the things that we were thinking about.
Thank you. Marcy?
Thank you, Chair McCormick. I just wanted to share with everyone that my name is Marcy Riva. I serve as the Executive Director of the Department of Indigent Defense Services, and I mirror what Lisa said about the excitement of this misdemeanor committee coming together to study this. I wanted to make this committee aware that the state of Nevada has entered into a stipulated consent judgment. And in short, the state of Nevada was sued specifically in some of our rural counties for failing to comply with the Sixth Amendment and provide appropriate representation in those rural communities. As part of the agreement, the Department of Indigent Defense Services undertook a workload study to determine how many or how much time should be spent on certain cases by case types. And we are required to comply. The state of Nevada is required to comply with this workload study within by November 1st of this year. In the rural communities, which this is limited to, it calls for an increase of 30 full-time equivalent attorneys. This is going to be a hardship because we are struggling with a nationwide crisis of a shortage of indigent defense providers. It's not just us. Oregon, New Mexico, basically most of the West Coast is really struggling with trying to find indigent defense providers. And many of us are in lawsuits with the ACLU regarding a lack of criminal defense attorneys. What other counties or what other states are looking at to try and comply with these workload studies? Because the reality of finding enough attorneys that we really need to fill these spots is going to be a challenge. So they're mixing that with an alternate of trying to decriminalize certain crimes that are nonviolent or have no victims. And that's something that's being done by Oregon as well as New Mexico. So I'm happy to provide any data that this committee needs as to how much time should be spent on these cases by the attorneys. So I just would hope that that would be in the back of our minds too, is that the state of Nevada is obligated to provide attorneys to these cases. And one possible solution is us to reduce case types where we need to have attorneys appointed. And by decriminalizing some of these misdemeanors, that could be part of our solution. Thank you.
Thank you, Marcy. And when you say that, I'm assuming we're talking about misdemeanors for which people face a loss of liberty. So then they're entitled to representation. So I think, again, that's I think that's a great point. I think that's a great point, and something that we should probably be looking at is which misdemeanors in the state are we currently looking to punish folks or to incarcerate them for the up to 6 months? And is that reasonable for those offense types in the opinion of this committee? And is that a recommendation that we make to potentially make those make some of those offenses non-criminal, or to specifically say that folks who are convicted of those offenses do not face a loss of liberty? I think we have Dean Hanna is next, and then John Pirro.
Hi, thank you. So my name is pronounced Hanan. I'm a professor of law. That's fine. No problem. I just wanted to say that.
I apologize.
No worries at all. For those of you who don't know me, I'm a professor of law at UNLV at the Boyd School of Law, and I direct a clinic where students represent people charged with misdemeanors in the Clark County and municipal courts. I haven't run it in the last couple of years. I've done a misdemeanor policy practicum where groups of students have looked at misdemeanor laws and policy and written policy papers, and sometimes at the request of lawmakers and groups such as the Fines and Fees Justice Center. And I echo what Lisa Mosley Sales has said, and Marcy Riba. I do wear another hat. And my other hat is I'm the monitor of the lawsuit that Marcy Riba mentioned, the Davis lawsuit. But I'm here in my capacity as bringing the the law school perspective as well. So 2 points. One is that in some of our research, we found that the drafting of some misdemeanor statutes is overly broad or overly vague in ways that is subject to constitutional challenge. Not a great way to change the law through the court process. So I'd be happy to work on this, and if the subcommittee would approve it, and engage some students in working on looking at the laws as well in terms of their drafting and their breadth. Second, in terms of the fines and fees, it's very hard to get the numbers on how much is collected versus how much is outstanding, and whether or not the fines and fees are really serving even the roles that their objectives and their roles. So I hope we'll be able to get more data from the courts about that as well.
And that's always been an area, Chair McCormick again, and sorry, John, to cut you off, but we'll go to you next. That has always been an area I think we've struggled with some data on, and nationally, the approximate collection rate, according to the National Center for State Courts, and this isn't specific to Nevada, is maybe around 40%. So that could be a starting point too, because I do know the National Center has some information on that. Mr. Pirro?
Hey, John, not cutting me off at all. No sweat. One of the things, again, I'm excited, as is Lisa and everybody else. My concern is, though, that sometimes when we change the law at the state level, then the municipalities go back and write their own misdemeanors into their municipal codes and kind of just subvert the work that we're doing. And I just want to make sure that we avoid that a little bit and keep an eye towards that post that. And figure out how we track that data as well. Like if we're doing these changes and we're making great changes at the state level, but then we're losing data at the municipal level and the county level.
I do have a question for you, Mr. Duncan. As Marcy indicated, I know there's a real shortage of indigent defense providers. Are you encountering that from the prosecutorial side as well?
Well, we actually have a contract, of course, with some contract public defenders that do some contract work. So we actually have pretty good resources in the city of Sparks in terms of providing the indigent defense here. So we're not seeing that. Of course, we have a pretty small court and just 2 prosecutors in the city of Sparks. So not something that we're currently facing, but it is a contract that is through the city, and we engage private attorneys for that.
Thanks. And have you had difficulty, if you've had vacancies within your office for prosecutors in filling those positions?
Thankfully not. We were able to fill our positions, and haven't had many people transition out. So yeah, I'm fortunate.
Appreciate that. Thank you. Any other comments on areas for study? I think that, and this is one of the difficulties sorry, Judge Cruz, I see you there. I will shut up.
You know me, I just hide in the background. One of the things, and I know John Pirro, sits on the CJCC subcommittees down here in Clark County. And it just seems to be something that I think dovetails into a lot of the discussions that we're having, is if there's an appetite to be moving into looking at some of these, changing what the laws look like, looking at a decriminalization, and, having it where you don't have the municipalities just recreating the wheel at a municipal level. Maybe part of our study should try to see if we can figure out, who are these people that are getting some of these lower end misdemeanors, because we do see certain subsets, unfortunately, that do have propensities for things just due to quality of life type crimes. And if that's the case, and we're trying to find ways to use some data to identify them, and maybe what are better ways that we might be able to deflect them from even getting involved in the criminal justice system, and even having that misdemeanor charge, which, just has that cascading effect as to everything that everybody is talking about, as to, who's, who are we representing? How can we find enough people to represent, talking about incarcerations? I mean, it's a very large systemic thing. Some of the things that I know John Piro and I saw just as a subset as to what was going on in Miami-Dade. We went down there to see, talking about mental health issues, and a lot of the things that they did was creating better programs for people to intersect that were having these issues that ended up having that they closed down a jail. I mean, I think it goes hand in hand, and that might be something that is worthwhile for us to figure out how we try to look at collectively as we're looking at some of these other issues.
Thanks, Judge. Mr. Arcata?
Yeah, thank you. Good morning. And don't mean to be redundant to some of the comments you made, Mr. McCormick, but I think regarding sentencing with misdemeanors, we should consider the sentencing structure, perhaps caps on certain low-level misdemeanors, maybe a sentencing structure similar to what we have in felony courts where you have a mandatory minimum and maximum sentence served. And then also for violations, consider doing, as the parole board's doing now, of dips in custody so that people that are convicted misdemeanors, they spend a week in custody or more, they're going to lose their housing often, they're going to lose their jobs, they're going to lose so much for these. So I really think we should look at the sentencing structure as we have it now. Candidly, my experience is it's either 30, 60, 90, 120, or 180, and it's usually 120 or 180, and a violation puts someone in custody. This also serves the purpose of reducing jail population, which I believe, and I haven't seen the stats recently, but some of the last stats I saw, at least at the Washoe County Jail, over 40% of the jail inmates were misdemeanors. So these are areas that I think we should consider or look at.
Thank you. All righty, Ms. Mosley Sales again?
Yes, and please let me apologize for not introducing myself when we first started. Lisa Mosley Sales, I'm the Nevada State Director for the Fines and Fees Justice Center. And going back to the data, I think the starting place for us should be going through that list of misdemeanors. And for those of you who have not seen it, it comes from LCB, the research division. It is 80 pages long. It is comprehensive, but it only encompasses state misdemeanors. I think that's a great starting place for us, just to go through that list of misdemeanors and collect as much data on all of those. And I think from that data, we'll start to be able to see where these other areas, these are all really good ideas. I particularly like what Mr. Arcata was saying. Get that data not only to say, but we're also going to need county jail data. We're going to need probation department data. Those are some of the areas. I think once we start to get all of this data, we can start to see where the most common misdemeanors are. We can start to hash out some of those collateral consequences. So I think a great starting point for us is just to begin to go through that list and collect as much data on each of those offenses as we can, and where those offenses are happening, who they're happening to, and then we can start to hash out some of these other ideas about sentencing. Definitely need to be looking at sentencing, definitely need to be looking at the fees, the fines that come with them, but also maybe be able to find a way to find out personal data, like what are the not only collateral consequences, but what are some of the other issues that come up when people are in the system. I love what Judge Cynthia Dustin Cruz was saying. So I think starting there and getting through that, hashing that out will be a good place for us to start, and will help kind of ease us into some of these other areas that we're talking about.
Thank you. And I think that's sort of, no, and I agree. And I just think that part of this first meeting, or at least my desire was to focus us on that data collection and where we want to go, because as I think folks have indicated, and we can see here, this is a giant area of study to look at, and there's many ways to approach it. Marcy?
Sorry, Chair. One thing I forgot to request is it possible to have the courts track whether or not an attorney is appointed in the case? We are very interested in how many of these misdemeanors attorneys are being appointed to, and members of this committee may or may not be aware, but there is a maximum contribution formula, which was put into statute in Assembly Bill 518 in 2023. And basically what it says is it's like a high deductible healthcare plan. Counties pay for indigent defense services up until their county max. And once they reach that max, they can be reimbursed anything over and above that. So we've effectively, last year, we reimbursed our counties over $3 million for these increases in indigent defense. But we just don't have data from the court in what percentage of cases that are being filed are attorneys actually being appointed in. We do have the information once the appointment takes place, but the problem is our data collection points are different than Department of Sentencing collection points, as well as the Administrative Office of the Courts collection points. So I don't know if there's some way to obtain consistency, so all of our data is comparing apples to apples rather than each of us collecting different data. But if we could track when attorneys are appointed, that would be helpful for us. And I think it would also take into consideration the fiscal note of what these changes may be for the state. Because if we do recommend decriminalization or changing certain things, that likely would reduce attorneys being appointed. And again, we do have data on how many hours by case types attorneys are, supposed to be spending on those cases.
Thanks. Not to put the judges on the spot, but I'm going to. How difficult would it be from sort of the court staff perspective and also the court administrators to collect that appointment? And because I know obviously you have who an attorney is on a case, but to differentiate between appointed counsel and retained counsel, or if that's even a concern.
This is Judge Cruz. That's going to be with the volume that we have in Las Vegas Justice Court. If you want me to have a mutiny in my clerk division and in my IT division right now, I'll go see if we track it. I mean, I can give you we could probably run basic numbers as to, when counsel is appointed, because I think that we have that tracking in there and I can give you that, but trying to go between retained, one of the conflict attorneys and one of the public defenders, that might be a little deeper of a dive. That's more difficult, but I can try to see if we can run kind of some of those just broad brush numbers to get an idea and carve them out into misdemeanors, because I will say our numbers, of course, are going to swell with a lot of the stuff that we have going on down here.
Right. And is that a concern for the group that Judge Cruz brings up between public defender and then obviously conflict counsel, if that's something we think is important, or is it a more broad picture of just misdemeanor cases in which there is appointed counsel?
Well, to jump in, I don't know if it's possible for us to do data on conflict because the public defender is appointed initially and we track that. But if they're conflicted later on, I don't think there's a way to figure that out. As far as private counsel goes, anecdotally, it's got to be less than 1% of our cases. I mean, when I started, half the cases were private counsel. I think it's very few and far between. So just about, unless they refuse the appointment of a public defender in Sparks, everybody gets a public defender appointed as soon as we can get them to fill out the paperwork, which is at booking. So when I've got PCs running here for people arrested yesterday, I'm appointing the PD in every single case as I'm doing them. So I think everybody gets a public defender. I think just about probably 99% of the time. But I think we can run who has one currently. Splitting out the data finer than that, though, I'm not sure we can do that.
And we're pretty much the same here in Ely. I imagine DIDS would be able to break down the conflict and the public defender cases because they're the ones who pick the conflict counsel. But trying to figure out who has public defense or who has a private attorney, virtually none. There'd be a lot of work to find out. There's virtually nobody.
Thanks, Judge. See, we've got 4 folks with their hands up. I think Mr. Duncan was next, and then Professor Hannon. See, I can say the name right eventually. And then Ms. Grosnick and Ms. Riba.
Well, thanks so much. I think Mr. Pirro had mentioned that the Miami-Dade model, but I do really think that this committee should do some serious consideration for like a pre-booking diversionary program for those with serious mental illnesses, right? And catch those that are, up in Washoe County. Judge Walker up here and others are trying to kind of spearhead those efforts. But I really do think that would be a game changer in many ways if we could be able to. I mean, if the state really wanted to get serious about pouring resources into something like that, where we could have that great wraparound services, catch people early, and misdemeanors, get them the rehabilitative help that they need, and be focused in that area. I think it's important. I do too think that some sort of structure in terms of having some clarity as to what offenses perhaps may require DAS, supervision, or some of the tail provisions that you talked about, John. I think might be important to look at, I mean, I look at our role as misdemeanor prosecutors with the hope to trying to rehabilitate people at this level so that they don't commit more offenses and they don't get caught up in the felony system. And so, of course, we encounter lots of folks with serious mental illnesses that continue to get caught in the revolving door here. And so I do think that Miami-Dade model is something that I think could be really effective and spend some money up front, but then save a lot of money on the background. So I think we should take a look at that. Thanks.
Thank you. Professor?
Hi, yeah, thanks. I just wanted to follow up on Marcy's question about appointment of attorneys, and just note that in 2019, the law regarding appointed counsel was broadened, and now it states that every defendant accused of a misdemeanor for which jail time may be imposed, and of course anyone with a gross misdemeanor or felony, is entitled to appointed counsel. And that's a little broader. So as we went out with my students to different courts, municipals, and some justice courts, it was the practice in some not to appoint an attorney if there seemed like there was going to be a workout for a fine only. Under the 2019 law, it doesn't look like that would be compliant, because the statute, because jail time may be imposed, it uses that language. So that's my reading of it. I just want to flag the issue, because as we're counting number of attorneys appointed or how many attorneys are needed, we should think of it in terms of any misdemeanor for which jail time may be imposed, which is at this point all of them, I think, right? Since the statute just says 6 months is the max for all.
And thank you, Professor. And I think that circles us back around a little bit to some of the ideas we had talked about a little bit earlier, as far as which are jailable misdemeanors and which are not. And after we collect the data, is that a recommendation that we want to make? That and just hypothetically, if we say went to a classification system like we have with felonies, so A through E misdemeanors or whatever, so it's like E, D, and C aren't jailable, or something to that effect. But I think, again, that's a solution that would be very appropriate for this group to look into, provided we can get that data. And I mean, I think from this meeting, it may seem a little bit overwhelming, and my intent is to get with the staff of NDSP and start talking about how we're really going to start looking at this data and what we can get, what exists now that we can get reasonably, what exists, what do we want that we're going to need to ask people to track that they're not tracking now, and all those type of things. All right. Sorry, I do not know who was next, if it's Marcy or Ms. Grosnick. How about Ms. Grosnick?
Thank you. I want to echo everything that Marcy said. I agree wholeheartedly with her, and that, some of the issues with workload on the PD should be part of the analysis, because fundamentally, the jurisdictions do have to provide indigent defense for cases that are prosecuted with a potential jail sentence. And so it's just a question, you know, of where we want to go with that and whether we want to focus on treatment or jailing people. I know we can get into that later, but back to the point about whether we can track appointment of counsel. I believe in the justice courts with the Tyler technology, I think an event code can be put in. It might be something that has to start now and go into the future. I'm not sure if it's something that we can go backwards and look at. And Judge Higgins might be able to correct me if this is wrong, but I know that the court administrators have, from the 2 justice courts in Washoe County who are here, have represented previously that they can put event codes into that program and then track, you know, like competency requests and conflicts. And I'm sure if that's possible, an event code could be created for, you know, public defender appointment. So that's just one thing to be aware of. We're not the biggest county, but we're also not the smallest. So the data could still be useful, even if not every jurisdiction can do it right now.
Marcy?
Thank you, Chair. And just to confirm, I was just asking for numbers of when counsel is appointed. It doesn't matter to me whether it's a county public defender's office or a conflict attorney. We're all one system, and we need to make sure that we have sufficient coverage for everyone. The reality is there's going to be conflicts out there, and we need to make sure that we have enough attorneys that are able to pick those up when the public defender's office isn't available to cover it. So for purposes of my request, there was no need to differentiate of whether there was a conflict by the public defender. I was simply requesting how many cases are we actually appointing counsel and how many cases is no counsel appointed. That was my only question.
Thank you. Judge Bishop?
I had 2 things. With respect to when the counsel is appointed on a misdemeanor, there are some cases where I'm not going to impose jail, even though it's an option. Citations, when the state doesn't show up. We had a truancy this week where I'm just not going to do it. So I didn't appoint counsel on those because while technically it is available, it's not going to happen. So that's kind of how we've read that statute there. With respect to figuring out the number of cases, public defender, I think it would be relatively easy through my jurisdiction because I think they have to report to DIDS the number of cases they've taken. If DIDS said, well, they had 200, and then we pulled a number that says we have 500 total, 500 minus 200 is 300. That should be fairly easy to do that math. And I'm pretty sure they have all those reports they have to do.
Thanks. Mr. Young?
Good morning. For those, again, I'm standing in for Nick Graham, who is our supervising team chief for our misdemeanor team. I supervise our criminal division at the Washoe County DA's office. Just a couple general kind of comments and thoughts, and actually to echo what Judge Bishop just mentioned. What we have historically done here in Washoe on misdemeanor offenses is at the charging time on a misdemeanor offense, we will identify in our complaint, our charging document, J or NJ, which if it's an NJ, no jail, it is telling the court we are not seeking jail time even for a misdemeanor offense. And again, historically speaking, if the court were to appoint a public defender beforehand, that's outside of our control. But if the court were to wait to appoint a public defender till the filing of our complaint, that would in itself significantly cut down the appointments because we are not seeking jail. So even though the statute might read, the potential for jail, we're saying we're not, and historically the courts are acknowledging, hey, we're also not going to impose jail. We're going to treat this as a fine only. So that would kind of influence the stats that are drawn. You're going to have a large swath of misdemeanor charge cases where jail for all practical purposes is not even is on the table. So that would be one thought. The Miami-Dade model, and somebody on the call mentioned, Judge Walker in competency court. I'm very familiar with us standing that up. I represent the DA's office since the start through now of all competency court matters. And what I would say is it is a step in the right direction, definitely, to identify people whose mental health concerns are the driving factor behind the crimes they commit. And we're trying to, and we are making significant progress in, divert is one of the big words being used, divert that to kind of wraparound services. But with that said, what I've also seen is that speed in that would have a negative outcome on success. So what we are typically doing is, trying to push somebody out of custody and just let them do it on their own without proper services, without proper housing, without proper medication and a treatment plan. We see those people back immediately. What we are trying to do here is, within reason, of course, slow things down to make sure they have, first and foremost, housing, which seems to be one of the primary triggers for success. But then all these other things that get there. And so, on one hand, where we're saying, hey, misdemeanants, let's get them out as quick as possible if there's mental health concerns. I think we need to take a step back from that and say, let's try to release somebody when it's safe and appropriate to do so for that individual. And that's going to be on a case-by-case basis. The public defender I work with, we're constantly talking about, hey, is this the right time? Is this appropriate? And we're treating that there. The other 2 points I would make is, with Valdez, with the legislative enactments, we are seeing misdemeanor offenders being released, I would say, quicker than in the past. And so that I could see having an impact on negotiation, jail, revocation, and all the things that flow from it. And then lastly, just a general point, because it hasn't been brought up yet, is, our office is a prosecuting agency. Our guiding principle is public safety. And in seeking justice, I would encourage this subcommittee and any working groups that come from it to at least recognize, even if it's not embraced, recognize that public safety needs to be a balance in the equation of what we're looking at. And, when it comes to decriminalization and releases and all that thing, our office is happy to have that discussion and look into things. But our office will always kind of come back to the forefront of, hey, is this a positive forward movement for public safety and for victims? And that's going to be kind of our guiding light in a lot of this. We are committed to looking at better practices, right? Competency courts, especially courts we're a part of. So for a long time, our office and I know other prosecution offices have shown our commitment to those things. But we do in the discussion need to balance public safety.
Thank you, Mr. Young. And I think that's important for this group too. And I think it dovetails with a lot of what has been said in terms of, with mentions of decriminalization, and those being the nonviolent, non-victim, for lack of a better term, offenses. Because I think if this group were able to focus on that and make some substantive recommendations on decriminalizing those, making them civil, however we do it, that would hopefully then free up both prosecutorial and defense resources to focus on those cases that have a bigger impact to the community. I don't know if Professor Hannon or Judge Higgins was first, so I'll flip a coin and go with Professor.
Oh, I think it might have been the judge, but this is pretty quick. I just wanted to say, I see, I think we are circling back to the idea of looking at the sentencing structure again, because, is it possible that it's minimally compliant with the law to say, well, if the judge is not going to impose jail time, you don't need to appoint a lawyer. If the person doesn't pay the fine, if they're in that 6 months max sentencing structure, then they could be sentenced to jail time later, even though it was a fine only initial workout. They might get a lawyer at that point. Does that comply with the statute? I'm not sure. So this is more of, I don't want to get too far into the weeds, but I think it's the big picture is, I think, looking at sentencing structure for misdemeanors and considering whether they should all be 6 month maximums or some should be no jail time or less jail time is a great move.
Thank you. Judge Higgins?
Well, to the extent we're going to start deep diving into data, it might be helpful, Mr. McCormick, if we get a database computer type person involved in this, because I know the AOC has spent years trying to make sure all courts count everything the same way. You know, there's half a dozen different case management systems. The jails use different systems. And what I mean by charge might mean something different to somebody else. And don't take this as a brag. This is not the first committee like this I've been on, and we spent a lot of time 20 years ago arguing about what a charge was. Is that a complaint a charge? Is each count a charge? And in courts were counting those completely different ways. So getting into that data is difficult. And I can say Odyssey is helpful to a certain extent, and I'll ask those questions. But I've asked a couple of times, I said, I'd love a report that shows everybody in Sparks that's been in jail for more than 6 months and has a bail less than $500. And Tyler says, we can do that for you, just $20K up front, and we'll start, and we probably get to you in 2 years. So it's all us liberal arts majors think that it's easy to get data out of systems, and it's not always as easy as we would like. And maybe it's a prospective thing we need to do, but I don't know if you could, at the risk of volunteering somebody from the AOC that is a data expert, maybe that would be helpful to get us all on the same page if we're all counting chickens the same way.
I am happy to voluntold somebody, so I will figure that out, and then we'll get back with that individual. And I see Judge Bishop covering his face there because he heard me say voluntold, which is very dangerous. You're on mute, Judge. Judge Bishop, you're still on mute.
I muted myself. I unmuted and muted. Sorry. I just wanted to soothe Professor Hernan's concerns about suspended sentences. Even if there's a suspended sentence, I'm going to give you counsel. If we talk jail at all, you get an attorney in my court. And I see Mr. Young is nodding his head as well. So it seems like that we're taking care of that the same way.
Right. So I think that lends itself then to the question about if they're not complying with that suspended sentence or the fine, then we're going to jail there. Is that an area? I think, again, that's an area we want to look at, because I think noticing this morning, we want to look at everything. So again, I think that that'll have to be a discussion going back with NDSP and figuring out how we can begin to systematically collect some of this data to make this this project more sort of doable in small bites, because you know, if we just kind of begin to address everything all at once, I don't know that we'll make a ton of progress. Judge Higgins, did you have another one? And then apparently not. And Lisa, please.
Judge Higgins, you didn't have a question? If you're not, I'll jump in. Regarding when an attorney is appointed, I'd also like to know if we can collect the data on if there was a charge to the defendant, if there was a counsel fee charged to the defendant, or if there was not. I'd like that to be one of the data points. Also, I don't know how the judges do that, if your systems track that, but I think it's important for us to collect that and to know that when counsel is appointed, if there is a fee charged to the defendant.
Any comment on that one? All right. So obviously here we've talked quite a bit about what we want to look at with this group and how we kind of want to proceed. And I think it will require some conversations after the meeting with Georgia and her team about sort of systematically rather looking at some of this. And if nobody has any other comments on discussion for areas of study, that will bring us to item 7 on the agenda, which is a discussion on working groups. And the question I would pose is, before we're able to sort of, I think, map this out, where we're going to go and what data we want to collect, is now a time to talk about what working groups we think we're going to want, or do we want to save that till the next meeting after maybe we've thought about what data and how we want to do that?
I think you might want to save that and then just kind of roll out some of the talking points that we addressed today and put it down on paper and let us kind of digest it. And then it'll be easier to map out a working group.
That was sort of my thought as well, Judge. I appreciate it. So anybody else want to just, you know, have a counterpoint on that, or want to start suggesting working groups now. And maybe the first thing we would do is create a data working group to begin helping Georgia and her team in that, and perhaps start interfacing with the various partners that we're going to need to be asking for information. So that I think is definitely a possibility, but I think, as Judge Cruz indicated, it might be a little premature to start doing that now. Again, I don't want to just hear myself talk in an echo chamber if someone has points here.
I'm sorry I arrived late. I had to, my calendar was out of control. Do we have a bill draft for this committee?
As I recall, in Senate Bill 103, we do not have a specific bill draft for this committee. We make those recommendations to the Sentencing Commission. Georgia, I don't recall, does the Sentencing Commission have any bill drafts assigned to it, or do we need to pursue those?
We use the departments, so my bill drafts are what we use.
And how many drafts do you have?
Actually, we just have one.
Okay. And now, obviously, I can't volunteer this on behalf of the Supreme Court or the Judicial Council, but the judicial branch has 10 bill draft requests as well. So depending on what recommendations come out of this group, potentially we could ask the Judicial Council to afford us a bill draft also.
And the reason I asked, that means we have to have something in place by September, right?
Yeah, the deadline for, well, at least for the judicial branch's bill drafts pursuant to 218D, is on or before September 1st in the year immediately preceding the session. And again, and I know that Georgia on the executive branch side has some other deadlines too, working with the governor's office, et cetera, that are even farther back. So, Ms. Jones-Brady. So you have your hand raised. You're still on mute.
I was just going to say the AG's office has 15 also.
Thank you. Marcy?
Thank you, Chair. For a data collection point, and I don't know if the Department of Sentencing already has this, but of the misdemeanors that are placed on probation, if we go by county, how long are our justice courts placing these people on probation? It's my understanding that some counties are actually placing people on probation for that 2-year end time at the start. So I think it might be helpful for us to have information of what is the reality of what we're doing, especially for us in those rural counties. How long are they putting those tail ends? Is it common to have the 2-year? Are we seeing something less? And then also, are judges continuing to hold status checks while that person is on probation? We're hearing that, you know, although they're on that probation for 2 years, they're required to come into court for monthly or, you know, multiple status checks in some of these areas, which again, I think this is more of an issue in some of our rural counties, which again relates back to the attorney time and whether or not that's appropriate for the judiciary to be holding status checks while a person is on probation. Just kind of wondering if we could get a reality, like a realistic view of what is misdemeanor probation looking like, because I don't know if a lot of us actually see it on a day-to-day basis to know what's actually going on in each of our counties.
And again, thanks, Marcy. I think to piggyback off that too, I mean, we have only a few jurisdictions in the state that have that Department of Alternative Sentencing / misdemeanor probation. We got Carson, Douglas, Washoe, Clark, and I don't know if, oh, no, Clark Alternative Sentencing, Judge Cruz is correcting me there.
It's at the municipal level, but it's not at Clark.
Thank you. You know, so we've got, well, then Las Vegas Municipal, but not countywide. So obviously it's a pretty big mishmash there. And I know a lot of other jurisdictions don't. And I think sometimes, and this may dovetail with what Mr. Young was talking about, you know, is there a concern on public safety, which is driving folks to do these sort of longer probationary terms? But again, I think that's part of the discussion we can have. Lisa, again?
I want to reiterate my idea about the working group. I do think it's a bit much to take on in this meeting, but Chair McCormick, perhaps when you send out the notes and the data points that we discussed, you could also send out that list of the 80 pages of state misdemeanors. They're all categorized. And I think once we all look at that, I think the working groups will develop organically from those categories. And so that's just my idea. Just all of us can be looking at that and thinking about how to, there's a lot of different categories. Some of them can be a working group that focuses on 3 or 4 different areas that are related. So that's my idea in the working group. And I think when our next meeting, we could probably have that together.
I appreciate that. Thank you for the suggestion, because, this is sort of a big topic in a big area, and I am just ready for all the help that we can provide each other to try to improve this situation and make those substantive recommendations for improvement. So I think that again leads us into agenda item number 8, discussion on next steps. And so I think, and please jump in, that what we will need to do is working with Georgia and her team to get the meeting notes, kind of iterate the data points that we have talked about, and then potentially provide that separately from the minutes, along with that list of misdos to the committee members, so we can begin looking at that and starting to formulate our thoughts on what we want to do there. And then as we refine those data points, then as I indicated, I will work with the Department of Sentencing Policy to see what we can get, what we know we have access to, points that we don't think anybody is collecting that we're going to need to ask people to collect. I will volunteer somebody from the AOC to join us on that, and to provide data. I mean, not to go on too much of a self-aggrandizement tour here, but at AOC, we are working on right now implementing what we're calling a data repository that will hopefully allow us a significant, and obviously it's a long-term project, but we're starting to get the first few courts connected, that will give us a much greater ability to dive into court data without necessarily causing the upset that Judge Cruz talked about, where her staff has to fill out the worksheets and create that. If we can come up with a way to do that electronically, that will allow other staff to pull that and not put that burden on clerks. Because I think for a long time, at least in my experience on the court level, and feel free, anybody else in a different sector, that we need the data obviously to inform what we're doing, but then it becomes a double-edged sword, because the staff that courts have in place to process cases and help litigants when they come to the court, etc., then sometimes end up swinging on the collecting data side. So that's a little shameless self AOC promotion there. So I think moving on to item number 9 here, as far as potential topics for future meeting, I think we've kind of narrowed that down to data elements, and then misdemeanors, and then we'll send that out. And before the next meeting, hopefully all the members of the subcommittee will be able to look at that and kind of formulate some thoughts and working groups. And then hopefully we will be able to return and have a better idea about what data we can get now, what data we can get later, and what data we're going to have to ask people to collect further, so we can maybe prioritize that collection and the areas we're focusing on. And then, so if that seems like a reasonable next step, glad to take that on and begin working on that. If anybody has any other ideas, what we should do, I think, kind of making this incremental may help, because it is, as I think is pretty evident now, this is a pretty big area that we're going to need to look at a number of things. And so then that leads me to my next question. Do we want to have subcommittee meetings monthly at this point? Do we want to what frequency do we want to do, or should I speak with, or should we work with sentencing policy to see what sort of timeframes we can have for some data and some of that discussion before setting another meeting date? And then also, which days work best for you? I don't know if Friday mornings are good for people. If there's another day, I would certainly like to make the meetings at a time where the majority of folks can attend. So any feedback on that is greatly appreciated. Marcy?
I'll provide feedback. This is for the Department of Indigent Defense Services. This is so important for us to be looking at these misdemeanors because we feel that this is truly part of Nevada's possibility of addressing our shortage of public defenders. So I would hope that we could meet more often than not. I think the judge did bring up that we have a short time period before our bill drafts are required. And even if we can reduce the number of cases or decriminalize certain cases so that we don't have to have public defenders there. Again, I can't state strongly enough that we have a shortage of public defenders across Nevada. Our current public defenders are overworked and we need to do something. So I would ask if we could meet monthly. I'm willing to do whatever is needed to be done to try and get this moving forward. And like I said, the Department of Indigent Defense Services is on a very short time frame where we do have to have compliance with that workload by November. And I think that taking steps like this, the state of Nevada could show the judge in that Davis case that we are actually addressing this shortage. So I'd ask that we meet more often so that we can meet our BDR deadline.
Thank you. So with that, unless anybody thinks differently, we will look at a date in April for another subcommittee meeting. So that would be sort of my recommendation here is we do that. And then we'll send that out again with the information. Lisa?
No, I was gonna just reiterate what Marcy said. I think meeting more often than not is very important. But I also think looking at some of the deadlines that we have, I don't remember which judge it was, if it was Higgins or Stephen that mentioned BDR deadlines. But if I'm not mistaken, I think there are some report deadlines from Georgia's office. I think just taking all of those deadlines into consideration and thinking about what data we have and how soon we could get it kind of guides when we should meet and when we should think about forming subcommittees. But I am all for meeting more often than not. Marcy said once a month. I think this is pretty ambitious, but I'm certainly open to meeting twice a month if we need to start, because we do have a lot of work to do on the front end before we even get to the point of making recommendations. There's a lot of data to collect. There's a lot of things, even just on this meeting today, that we've heard talked about that I hadn't considered. And so there's just a lot of work to do on the front end. So I'm totally open to meeting as often as other folks are willing to meet, but certainly at least once a month. But if we can meet more often, I'm open to that as well.
Thank you.
Chair, could I just add one thing? I do have the budget timetable for the executive branch. The non-budgetary bill draft requests are due to LCB August 1st.
Thank you. And again, we do also, I mean, potentially have the option to interface with a legislator about getting bill drafts because they don't necessarily have those same constraints. I just raised that as a potential solution. But you know, as far as next steps, again, I think it comes down to me meeting with sentencing policy and kind of coming up with a game plan on this data and then providing information to the members of the group. And then we will look in April for another meeting date to reconvene, look at sort of what we've come up with, and then start looking at working groups to farm this out so we're not having to do everything as this larger group. And pursuant to Senate Bill 103, the working groups of this subcommittee are not subject to the open meeting law. So we will be able to convene working groups more quickly than we can convene a meeting of this full group. So with that, If nobody has anything else on that, we can move to item number 10, which is the second period of public comment. So just as we did during the first period of public comment, those who wish to testify, excuse me, may do so by telephone. Due to time constraints, public comment will be limited to 2 minutes. Any members of the public that exceeds 2 minutes may submit their testimony in writing to ndsp@sentencingpolicy.nv.gov. At this time, I would ask staff to manage and direct those who wish to provide public comment. Ms. Jones?
Thank you, Chair. Members of the public who would like to testify by phone, press *9 to raise your hand. When it's your turn to speak, please slowly state and spell your first and last name. And I do not see anyone who wants to participate in public comment.
All right. Thank you, Ms. Jones. With that, I would thank everybody for appearing and for agreeing to take on this Herculean task that we've all talked about this morning. And we will be reaching out and providing that information we've discussed. And Lisa?
I just want to say, if we don't already have, is it okay to have a directory of all of the members with our contact information? If everyone's open to that.
I think that's completely reasonable unless anybody has an objection. When I meet with Georgia and her team to give them a tremendous amount of new work, we will work on that as well. So with that, unless there's anything else, I will adjourn the meeting. Thank you for your time this morning. And we will be in touch relatively soon. Appreciate it, everybody. Thank you.
Thank you.
Thanks, everyone.